Thank you, Giuseppe, and thank you, Cristina Fassone, for this opportunity to talk about my book, Judicial Anti-Corruption Campaigns, Cases of Prosecutions in Italy, Brazil, and Romania. I wrote this book partially inspired by the narrative created in EU candidate countries, such as Bosnia and Herzegovina, a country that I come from, where all policy problems were considered, irrelevant or problems of second order compared to corruption. Corruption was the main explanance for every single policy failure and for most of the problems that the country would face. And so, as a lawyer, it interested me also why is the judicial response to corruption, something that is so much promoted as a primary component of the rule of law when the European Commission assesses the state of the fight against corruption in these countries. And so I decided to look completely out of the box. I didn't do a PhD on this. I did a PhD on how the countries that are, different, but that had comparative cases of massive legal and political mobilizations against corruption, how they have fared, and what has happened in such battles and undertakings, which is why I looked at the three cases of massive legal and political mobilizations that I called judicial anti-corruption campaigns in the three countries. And first, I looked at the drivers of these campaigns. So, why was it that the judiciaries or the prosecutors and the judiciary working together, why were they able to mobilize the population, and how was it that they were able to, take on so many cases in such a relatively little period of time? And I found that a concept very useful for me. This was a concept of judicial reputation developed by Tom Ginsburg and Nuno Garupa. Judicial reputation, meaning the stoke of past performances of the judiciary and the prosecutors, meant that the population can be mobilized and that political actors and civil society actors may be mobilized based on a belief that what the judiciary ought to do and what the society ought to do is fight corruption, and that the primary characteristic of what the society of how corruption should be tackled are these judicial means. I looked also at how judicial associations foster and help this mobilization, finding out that basically the interplay between them and strong judicial councils is the institutional architecture that allows for such mobilizations to take place. Looking at the rule of law challenges that the campaigns have produced, I couldn't have possibly looked into all of them because so many of them are there. But I have managed, I think, to be one of the first authors to compile them across jurisdictions. I have looked, for example, at how surveillance of the Romanian National Security Agency has shaped the campaigns, asking the question, was the Constitutional Court of Romania really able to conduct a judicial review of the instances of weaponization of such evidence? And has it been the case that really the National Security Agency of Romania has been the one choosing who gets or doesn't get to be prosecuted as a part of the campaign? I have looked also at the interplay between Deltan Dallagnol, the leading prosecutor of the Lava Jato cases in Brazil, and Sergio Moro, one of the leading judges who have tried the cases in these campaigns, finding the undue influence and discussing it that Moro had over Dallagnol. Finally, I looked at how different definitions and specific definitions of criminal acts in Italy, specifically the acts of extortion and the systemic corruption that existed at that time, made shape the tactics that the prosecutors used in order to obtain evidence. And I have realized that most of these rule of law challenges and violations happens in the process of the collection of evidence. The actual other problems that may arise are not as important as this one. Looking finally at the impacts of the campaigns, I have found out that Their most specific effect, unfortunately, is in the legal system, and here it is predominantly negative. After these campaigns, or even in their duration, judiciaries become targeted by the political class, and as a result, they become less independent, more polarized. Laws enabling the prosecutions in the first place become changed so that any such repeat of a judicial anti-corruption campaign becomes much less likely. Uh, in the political system, you do see demise of some actors or their loss of popularity, which may become only temporary. And looking also outside of the three cases that I analyzed, I think you will agree with me that prosecutions of political corruption do not now have the impact and stigma that they might have had in the 1990s in Italy and in France and Spain in that time. Looking at the economic effects, I find that they are extremely difficult to quantify. So that as an anti-corruption policy tool, judicial anti-corruption campaigns might not be your preferred tool of choice because the impact that they might have on the economic system in cases of Italy and Romania was very, very difficult to determine. They help privatization, but they don't necessarily bring about economic development, which is what you would expect for some theories explaining how anti-corruption policy tools work. Um, Finally, the overall rate and perception of corruption, quite simply, is not dependent so much on how much engagement against corruption happens, but rather on to what extent the citizens perceive their countries as unfair, to what extent the level of institutional trust exists in a society. And even if the level of institutional trust grows, making the judiciary more believed, if you want, of the three branches of government, that doesn't mean that the overall perception of corruption will go down as a result of these campaigns. And knowing this, some have suggested that we shouldn't really put much faith in how and why the judiciary fights against corruption, and that we should focus on preventative tools. I'm not so sure that actually preventative tools would be able to fully replace what we get to judicial anti-corruption campaigns. And I'm not also sure that it's a good idea to limit either through guidelines or some sort of very complex regulation the ability of the prosecutors to go against those who are politically corrupt. I think rather that judicial anti-corruption campaigns are a tool that costs a lot, creates a lot of risk, but is a tool that we should have at our disposal and use it. And if we don't use it, we risk, or we use it sparingly, we risk the emergence of such events and developments that we see, for example, in the second Trump mandate. So that's overall what my book is about. I'm open to all further questions